Welcome back. The state's new witness in the Senzo Meyiwa murder, Zandie Khumalo, has begun her testimony. In fact, Judge Tshifiwa Maumela dismissed her application to bar media from broadcasting her testimony in any form. The media has been granted permission to broadcast her audio but cannot show her face. Let's discuss that now with legal analyst Zola Majavu. Earlier on in the week, we spoke to you, Zola, and we're talking about the judgment which was handed down that indeed the media will be able to hear Zandie's voice, not necessarily see her face. And as things proceeded today, what is your legal reaction?
Good afternoon, and good afternoon to the viewers. This came as no surprise. I did anticipate that the judge would have to exercise a careful balancing act. Even if he dismissed the application, he didn't throw away completely out of the window the concerns that a potential witness had raised. And I believe that the decision that he ultimately arrived at was well reasoned, fair, balanced, and it strikes a delicate balance in a manner that does not compromise the nature of the evidence as well as the composure of the person who is about to testify. People must not forget that you may be a celebrity and put yourself out there in the public domain. But when you do so under less invasive conditions without the rigors and the pressures that court proceedings bring upon ordinary individuals. So I think the judge was absolutely correct, and he had to make sure that we get the show going. At least the witness is now testifying, albeit via audio, but it does not take away from the fact that you get to hear her voice directly as it is. And in instances where she breaks down, it's human. Sometimes we all get overcome by emotions. And can you imagine if she were to be beamed across television screens in that vulnerable moment? And I think the judge tried to safeguard all of those competing interests. And I think, in my view, it was a well-reasoned decision.
And let's talk about that, Zola, her breaking down during her testimony and then addressing the accused, saying, I see you, and, the trauma you put me and my family through at the time is inexplicable. Legally speaking, we heard, obviously, the lawyer of one of the accused objecting to that. Was that the right way in which to conduct herself? How else could that have played out?
Firstly, she is human. She's a non-lawyer. We legal smiths are used to these things, and we are not faced by court proceedings. However, one cannot blame an individual who is now forced to relive a very traumatic experience that has been with them for the past couple of years. So to the extent that she's a layperson, she could not be faulted. But in terms of court processes, that behavior is clearly unacceptable. And I think the defense who got on his feet and raised the objection was correct. And in fact, the defense, the state prosecutor was also constrained to concede that it is a fair point after he explained why it is that he was objecting. And the judge was also, in fairness to, in the process of addressing Ms. Khumalo, to say, ma'am, this is not how it is done. It may well be that it should have been anticipated that such moments would happen, and maybe Advocate Baloyi could have trained her better to anticipate what her reaction should be in the event she were to be overcome by emotions. But I think it's really no one's fault. The legal teams, inclusive of the prosecution, took the point, and the judge also guided the witness accordingly. There was no way in which a lay witness could have suppressed her emotions. We react differently to trauma. But I think the defense was correct in saying it is improper. Don't address our clients, address the court. Say whatever you want to say about them through the court as opposed to addressing them directly. That would have been unacceptable had it been left uncorrected.
And on that point, Zola, could it be at a later stage used against her by the defense?
Not necessarily. They wouldn't go very far because it is human to act out in accordance with our emotions. And sometimes these things are spontaneous. Of course, it's a different matter if she were to be caught out lying, because then they would say your breaking down was an act which was meant to defocus us from the truth. But it's still early days. She's still on the box. I cannot imagine how that can necessarily be used against her. And especially considering that it did not persist for long. As soon as it occurred, the counsel on behalf of one of the accused persons was correct. He was awake. He brought it to the judge's attention, and that matter was then resolved there and there. So I think it will really be of no moment, or it will be a cheap point in my respectful view. But one wouldn't know the context in which it might be taken advantage of. But to the extent that there was a slight irregularity, that irregularity was corrected and nipped in the bud as and when it happened.
Before I let you go, Zola, let's talk about the testimony that Zandie gave today. Obviously, she mentioned the issue of the bullet ricocheting and hitting her and her running to the bathroom, as it were. Just all of the details that came out of her testimony today, what do you make of that?
I think she would be very careful not to try and over-dramatize the issues, because that testimony is going to be cross-referenced against the testimony of the first state witness, who was a crime scene technician. And if they were to be at odds in material respects, that may potentially weaken the state's case. The one must also be alive to the probabilities. If a bullet ricocheted and it reacted in a manner that she describes, it may well be that upon closer scrutiny and cross-examination, it may be found to have been improbable. But I think perhaps she should stick to the factual observations that she made as a layperson and leave the optics of the specifics to the relevant experts. However, if she is able to say, this is what I observed, the bullet went from that point, it hit this particular object, it ricocheted in that direction, I hope that it will be corroborated by independent expert witnesses or testimony. If that does not happen, I'm afraid she would not have done the state's case any favor. But it's still early days. And remember, even if she were to be torn apart under cross-examination, Advocate Baloyi still has a second bite of the cherry in that he is still allowed to re-examine her. So we call it a bouncing back exercise, where in instances where she may not have come across elegantly or in a manner that is not satisfactory, the prosecution can still ask her questions to clarify her earlier answers. But that's what legal smiths do. I think we must be fair to her and allow her to testify in a manner that is less invasive, so that when she is subjected to cross-examination, it should not be when she is found wanting, it is because of the undue pressure that was brought to bear upon her. But I think the judge and the counsels involved, including on both sides of the spectrum, I believe they're handling this matter with the necessary circumspection that is required of officers of the law. There's no grandstanding. They are raising objections. They stand by the objections, and the judge rules immediately. And this is how a criminal trial should be conducted.
And should we read anything very quickly with the removal of Tefo earlier? Obviously, that was a dramatic scene. Should we read anything from that?
You know, the less said by my former colleague, Mr. Tefo, the better, because I do not want my commentary to be misconstrued as a personal attack. This ought to have been avoided. It should not have happened in the first place. And I believe that, with respect, he tested Judge Maumela's patience, and the judge could not take it any further. You would not want to subject yourself to that type of removal. As an officer of the court, or a former officer of the court, or a current officer of the court, you know the rules of engagement. If you are ordered by a judge to sit down, regardless of how animated you may be in your feelings, you sit down. When you are given an opportunity to speak up, you stand on your feet and you address the court as robustly as you possibly can. But there's a fine line between robustness and downright contempt and wasting everybody's time. Remember, those attorneys or counsel who are there are being paid by the hour, by the minute, by the second. And it is not fair on them and their clients for that time to be squandered in that manner by a person who is not representing any of the parties before court. He says he's got instructions on behalf of the Meyiwa brother, but that Meyiwa brother is not part of the court proceedings. So the judge was correct in saying, look, if you don't evict yourself, I will politely assist you to be removed by those whose responsibility it is to respect and maintain the decorum of the court. But quite frankly, my brother there could have just avoided this dramatic scene. We don't need this. It's a poor display, and people are watching. And there are people who must respect how lawyers conduct themselves in courts of law. If we are going to make a mockery of those proceedings, even when you had a good point, your point gets watered down because we are now focusing on the theatrics as opposed to that which you would have wanted to bring to the court's attention. There are ways in which you communicate to the court, especially if you are a watching brief. The nomenclature suggests that you watch the proceedings, you advise your client on what to make of the proceedings, and when there is good information that you believe may assist the administration of justice, you engage with your opposite number, who is the prosecutor, with full dominating powers to run the trial. You engage with them in a collegial manner. They in turn would then convey that to their opponents on behalf of the defense, and also to some extent, and if possible, to the presiding judge. You don't rock up and say, I am a watching brief, I want to address the court directly. It's unheard of. You may, as a watching brief, address the court on invitation by the court itself, if the court is of the view that you may assist and clarify a particular point. But you do not have the inherent right to demand that you be heard in instances where you also withdrew from record when you enjoyed the full participatory rights in those proceedings. You, on your own accord, said, I want to disengage. You brought an application to be recused. The court granted your own application. Now, within 2 shakes of a dove's tail, you want to come back and seek to address that judge. Quite frankly, if I were the presiding officer, he would not have gotten very far. He would have been ejected within the first few seconds of making an appearance, robed in attire that is a preserve and a privilege to be exercised by those who remain on the roll and are in good standing. But like I said, the less said by my former colleague, the better, because I want to keep giving him the respect that he deserves. And in my eyes, I continue to hold him in high esteem, even though I do not agree with the theatrics that he sometimes resorts to. I don't think it is assisting anyone, and it may well be that he's also not assisting those who gave him that mandate that he says he holds. But I think I should leave it at that so that I maintain my respect for him. He's a brother after all.